Today I'm talking about the 3 big lies that you might have heard about avoiding copyright infringement. You might think you're not committing copyright infringement, but you could be wrong. Did you get that reference? In this video, you're going to learn what every online brand needs to know about avoiding copyright infringement on the internet. And if you stick around to the end, I'm going to tell you about my new free resource for online brands when copycats strike online. I'm Maria Spear-Allis, lawyer for online brands and content creators, and this is the Spear IP Show. Lie number 1. If I'm not charging anything or making money from it, then it's not copyright infringement, right? Wrong. Copyright infringement is what's called strict liability. That's lawyer speak for just doing the act is enough. That there doesn't have to be any kind of intent to commit copyright infringement. You don't have to make money from it. Just the act of copying is copyright infringement. There's no requirement that you make money in order for it to be considered copyright infringement. Number 2, if I add a disclaimer or tag the original creator, then I can't get in trouble. Wrong. So wrong. Apparently I'm into quoting Mean Girls today. You've seen, I claim no rights to this music, or I claim no rights to whatever in people's posts, right? But like I just said, you've copied it. That's it. That's the infringement. Just copying or using someone else's material without permission is infringement. And I've heard of several photographers who actually track infringement on social media by the people that tag them. Using someone else's photo without their permission, unless you've properly licensed it somehow, is copyright infringement. Credit or no credit? Numero 3. If I found a photo on Google Image Search or on Pinterest, then it's royalty-free or public domain and I can use it and it's not copyright infringement. No. I had a client once that used a photo that he found on Google Image Search in a blog post. He got a big fat cease and desist letter from a firm that does volume copyright infringement work. That just means that they send thousands of cease and desist letters. That is their bread and butter. The photographers that they represent all register their photos with the Copyright Office. Very, very smart. And then they pay these firms to crack down on unauthorized uses. So this cease and desist letter asked for multiple thousands. Because based on the Copyright Office, if someone infringes your work and you've registered it with the Copyright Office, you get from $750 to $30,000 in damages. He didn't end up having to pay $30,000, but he had to pay something. Hear me on this. Google Image Search catalogs images from everywhere. They are not necessarily royalty-free. They are not necessarily public domain. Don't look on Google Image Search for free images. Nope. So the secret to avoiding copyright infringement online, use things that only you've created, or if you're using something that you didn't create or posting something that you didn't create, make sure you have permission. That's it. So I hope that helps you to better understand the 3 lies everyone believes about avoiding copyright infringement on the internet, and I'll see you next time. So I have this new free resource for online brands on dealing with copycats online. If you head to spear-ip.com/influencer, you will get this free download. I basically run through what you can say, what not to say, and a little checklist to run through before you contact somebody yourself. Again, that's spear-ip.com/influencer.